So, Judge Leigh Martin May, the judge handling the matter involving Lindsey Graham's desperate attempt to avoid testifying about Donald Trump's Georgia state election crimes, Judge May will not play on Lindsey Graham's playing field. No, Judge May has her feet planted firmly on the field of justice. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So the sad saga of Lindsey Graham's endless ducking and dodging, trying to avoid having to testify to a Georgia grand jury about Donald Trump's Georgia state election crimes, has taken some interesting twists and turns in recent days. So let's figure out where the case has been by going through some of the headlines, and then let's try to break down to its basics what is a pretty complicated and convoluted case. But let's first start by looking at where the case has been. So we're going to start with the following headline. Georgia's Secretary of State says Lindsey Graham suggested he throw out legal ballots. That sounds important. So not surprisingly, the next headline, Georgia grand jury subpoenas Lindsey Graham over calls. Those would be the calls to Secretary of State Brad Raffensperger, in which Lindsey Graham was urging Raffensperger to throw out lawfully cast ballots. So, after being subpoenaed, Graham ordered to appear before Atlanta grand jury investigating Trump. But Lindsey really didn't want to appear, so he filed what's called a motion to quash, a fancy word seeking to have a judge invalidate the subpoena and say, Lindsey, don't worry about it. You don't have to testify. And the judge who heard that motion to quash is a judge named Leigh Martin May. And the next headline, judge denies Senator Lindsey Graham's bid to quash subpoena in Trump election probe in Georgia. So naturally, Lindsey Graham had to appeal Judge May's decision. And the court that heard that appeal, the 11th Circuit Court of Appeals, put a pin in that, we'll talk about them in a moment, issued the following order. It reads in part, in response to an emergency motion by Senator Lindsey O. Graham to stay, that is stop or pause, the district's court order ordering him to testify, the 11th Circuit Court said, this case is remanded to the district court for the limited purpose of allowing the district court to determine whether Lindsey is entitled to a modification of the subpoena to appear before the grand jury based on any protections afforded by the speech or debate clause of the United States Constitution. And when the 11th Circuit Court of Appeals kicked it back down to Judge May earlier today, August 22nd, Judge May promptly issued another order in the case saying, oh, okay, fine. Lindsey, you have until 9 a.m. on Wednesday, August 24th, to file a motion as to exactly which questions and or categories of information might be protected by the speech and debate clause. So that gives you about a day and a half, Lindsey. Hashtag Judge May don't play. Okay, friends, now let's do the breakdown to basics. This is going to be a little bit of a Team Justice Law School class, so please hang with me. Let's talk about how the 11th Circuit Court of Appeals botched this one, in my opinion, and how Judge May will help the 11th Circuit clear it up. So ordinarily, when a witness is subpoenaed to the grand jury, if the witness believes he or she has some privilege that would allow them to refuse to answer certain questions, there is a tried and true method to test that privilege. So the privilege that a witness could have when appearing in the grand jury, it could be attorney-client privilege. It could be executive privilege. It could be the Fifth Amendment privilege against self-incrimination, which Lindsey Graham has. We'll talk about why that is in a minute. Remember when Donald Trump was called to testify in a deposition of New York? He pled the Fifth 440 times because his truthful testimony would have incriminated him, so he has a constitutional right to plead the Fifth. That's a kind of privilege. There's doctor-patient privilege, there's spousal privilege, and there's speech and debate clause privilege. You know, if a member of Congress says, no, the things I said, the words I spoke were part of my authorized legislative duties, well then perhaps he can decline to testify by invoking the speech and debate clause privilege. But here is how that plays out. The witness goes into the grand jury, and the witness is required to answer every single question the prosecutor poses that has nothing to do with speech and debate clause privilege. And that's why Judge May ruled that he doesn't have blanket speech and debate clause privilege, particularly when you think about it. He's calling a Republican Secretary of State of Georgia, a state where he has no constituents. He's not a senator from Georgia. And he is, quote, urging the Secretary of State to toss out lawfully cast ballots. Doesn't sound like a legitimate legislative duty. Call me crazy. And she ordered him to testify, but she didn't precisely say, okay, let's talk about every question you could be asked and whether any of those questions might have some lingering speech and debate privilege. No, Judge May just said, your motion to quash, to invalidate the subpoena is denied. Go testify. Now, the 11th Circuit said, no, Judge May, we're going to put a temporary hold on Lindsey's obligation to testify. We're going to send the case back to you, Judge May, remand it to the district court, and we want you to go through, I guess, a hypothetical question by question exercise, a thought exercise, an academic exercise, and see what questions Lindsey Graham might have a legitimate speech and debate privilege to, which is absurd. That's where the 11th Circuit botched it, in my opinion. Why? Because you can't go through that exercise. Nobody knows what questions the prosecutor will ask Lindsey Graham in the grand jury. And you can't make the prosecutor tip her hand and say, well, here are the 800 questions we intend to ask Lindsey Graham. Judge May, might he have a privilege to any of them? That's not how any of this works. Lindsey Graham should be ordered to appear in the grand jury and should go through the same exercise that mere mortals go through. Like if you or I were subpoenaed to the grand jury, we would have to answer each question until we got to an area that we thought we had a privilege, maybe an attorney-client privilege, maybe a Fifth Amendment privilege against self-incrimination, and then we could invoke that privilege and say, no, I can't answer that question because the answer calls for privileged information. That's how this happens in the grand jury. And then you go back to court and you see which questions Lindsey Graham refused to answer, and then you test whether he has a viable privilege to them. And if the judge says he doesn't, Judge May, orders Lindsey to return to the grand jury and testify about those questions that he asserted a privilege to, that Judge May concluded did not apply. The 11th Circuit has tried to turn it on its head. Before Lindsey ever has to answer a question, before Lindsey ever has to invoke a privilege, we're going to do all this as an academic exercise in the court first, and then he's going to testify? That makes no sense. It's not only impractical, but it's impossible. Why? Because when Lindsey Graham answers one question in the grand jury, that question may lead to a natural follow-up question by the prosecutor, and then that natural follow-up question might or might not involve the protections of the speech and debate clause. So this is the 11th Circuit, in my opinion, botching the whole thing. But Judge May is going to clean it up. Here's why I say that. Like it or not, the 11th Circuit said, Judge May, take it back and figure this stuff out. And she gave Lindsey Graham about a day and a half to file a motion laying out what questions he won't answer. What areas does he want to steer clear of? That's a bit of an unusual exercise because I predict the first thing his lawyer will say when his defense team files this motion by 9 a.m. on Wednesday is, Judge, we can't possibly answer that question because we don't know what questions the prosecutor will pose in the grand jury. That is actually a legitimate response. But like I say, Judge May don't play. So I'm confident come Wednesday or whatever day she sets the hearing, she's going to resolve this issue. Can I give you my sense of what she might say? She might say, okay, I tried to be nice the first time around. And I said, you know what? Motion to quash denied. Go in there and testify like every other mere mortal. Assert a privilege if you want, and then we'll litigate it. Judge May will probably say, I find that you don't have speech and debate clause protection to any of it. And even if you did, I make a further finding that the crime fraud exception might overrule any lingering speech and debate clause privilege you might otherwise have. Why? Because the other party to your phone conversations, plural, there were two of them, Brad Raffensperger, a Republican Secretary of State, one of your own tribe, Lindsey, said he interpreted everything you said to him as urging him, Secretary Raffensperger, to toss out lawfully cast ballots. That's a crime. That is the crime of soliciting election fraud under the Georgia state laws. So even if you did have some lingering privilege, the crime fraud exception overrules it. Don't know if that's where she's going to go, but I think she may be done playing and done being the nice judge, which she tried to be. If you read her first motion, she tried to go easy. She tried to dance around the question of whether Lindsey was obviously caught red-handed on those calls doing something wrong, as Brad Raffensperger said he was. So this is getting interesting. But take heart, because Judge May don't play. I predict whatever she does, she's going to do the right thing. But now let's tamp down expectations, because what happens after Judge May rules against Lindsey Graham again? He appeals again to the 11th Circuit Court of Appeals. And here's the last thing I'll leave you with. You may know, friends, that Supreme Court justices, each one of them, have some supervisory duties over each of the federal judicial circuits. Guess who has supervisory duties over the 11th Circuit Court of Appeals? Justice Clarence Thomas. Let's see how that plays out. Friends, stay tuned to this one, because I think in fairly short order we may get a pretty interesting ruling handed down by Judge Leigh Martin May, who, if I haven't mentioned it previously, don't play. Because justice matters. Friends, please stay safe. Please stay tuned. And I look forward to talking with you all again tomorrow.